Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. My co-host, as always, is Jesse Barrientes. Jesse, welcome to the show.
Thanks, Dave.
We're going to be talking about divorce and family law. We have two special guests, the Honorable Judge David Garcia. Welcome, sir.
Thank you.
And Angela Henderson.
Yes.
From Henderson Law and Mediation. Welcome to both of you. Thanks for joining us.
Thanks for having us.
Glad to be here.
Can you tell us, Judge, a little bit about your background before we get started?
Well, I grew up in Chicago, and I was I got married when I was 21, and I was going to college, and I worked full time during the time I was in college, and then I went into manufacturing, and I did manufacturing for a lot of years, and I always wanted to be an attorney since I was a small child. It was one of my dreams, but it almost seemed like I wasn't going to fulfill that dream. So
you fulfilled it and took it to the next level.
Yeah,
so
well,
congratulations to you.
So I went to law school when I was 35, and I came out of law school and I opened up a practice in Will County, and I represented the people. I didn't work for a big law firm. I worked for myself, and I did it for 18 years. And then in 2013, I got appointed judge.
Fantastic.
Yeah.
I understand you were the first Hispanic judge of any sort in Will County.
That's right. I was the first one.
Fantastic.
Yes.
And now you're running for circuit judge.
Yeah, I'm running for circuit judge, and the difference between the two is as an associate judge, I control my courtroom, and nobody pretty much messes with me in the courtroom. As a circuit judge, then I get a chance to run a department and make decisions that would affect the whole department, and that's what I want to do.
So policy-wise, in terms of...
That's correct. Yes.
Fantastic. And Angela Henderson, can you
Yes.
tell us a little bit about yourself and your role in Henderson Law and Mediation?
Okay, I'm the principal in Henderson Law and Mediation. I graduated law school when I was 40, and I started private practice the day after I got my slip. And I've been a solo practitioner ever since. I have 2 associates now who are very helpful. I practice only in family law. So I do family law cases. I'm also a mediator and a guardian ad litem, which are both family law-oriented side jobs.
And you also teach both of
I do.
those, so attorneys can be, for lack of a better word, certified?
Correct. Mediation, which is about a 45-hour class, I teach that. I also used to run the program at Lewis University. We had a mediation team that competed internationally and won international awards for mediation. That was a lot of fun. So I believe in mediation. I really think it gets a lot of people out of that courthouse arena and moves them on to having their post-decree life.
Fantastic.
And actually, I took mediation. I actually took one of Angela's classes, and the only thing that we didn't schedule real well was who brought the donuts. Because one time we had how many?
Oh, we probably had 13 dozen donuts that day.
13,000 donuts. Yeah.
Never
Or
too
a
many.
baker's dozen.
Yeah.
Over the years, Judge, if I can ask you, there's been some significant changes to the divorce and family law laws, thanks to the legislature in Illinois. Can you speak to some of those changes and how they've affected the process in the courtroom?
Well, one of them is that we don't use the term custody anymore. It's parenting allocation, which is kind of like a tongue twister. And most people still say custody because it's easier to say, but and I think that the legislature decided that it's important for a child to have both parents in their lives, and they're moving closer and closer to 50%, I think. I think eventually it's going to be 50%, as best you can schedule it. And so it's custody almost, I think it gives you this tone of possession where allocation is time with your child. So you don't possess your child, you spend time with the child.
Yeah, well, that makes sense because in other areas of the law, custody does mean to possess something, to have custody of it. But how do you work out a 50-50 situation where the children typically would reside with one parent on an everyday basis?
Well, you gotta, well, first of all, you have to send them to mediation if they're not agreeing. So you send them to a mediation, and the mediator is going to try to get them to agree on how it's going to be allocated. If they can't decide, then I'm going to have to look at different criteria, where they're going to be living, because obviously it's going to be very difficult 50-50 if one lives, 25 miles away or 50 miles away. So you try to work it out within the parameters that you have in that divorce. And sometimes it's difficult.
Yeah.
But you got you got to remember it's in the best interest of the child. So you try the best you can to have both families.
But one parent, because the federal and the school laws haven't caught up, which is just interesting, because I wouldn't think that would be that difficult to make that jump. But so for purposes of registering your child, one person is designated, what we're just talking about, the residential parent. But that isn't to be used against either party in the future to say, well, hey, I was a residential parent and I should have, a special preference.
Yeah, it doesn't, it's kind of a misnomer. I mean, it doesn't give you any extra power. It just means the child, for school purposes, this is their address. Because, as you know, in the county, you could live across the street from somebody and you go to a different school.
Right.
So you don't want to designate the parent as the residential parent if they're going to have to get out of that school and go to another school where they're not going to see their friends and what they've been used to all those years. You want to minimize the trauma to the child, and there is a lot of trauma to them. So you want to try to minimize that.
And sometimes the
Sometimes-
school, right?
Sometimes we call it co-residential parent if they live in the same school district and they have effectively been doing co-parenting, real co-parenting that we see a lot more of now than we used to 20 years ago when I started.
Any
so we
issues
call
with
it
the school?
No, as long as you call it, they've got a court order and they're afraid of lawyers anyway. And you have a court order that says they're co-residential parents, and the school won't care. You're both in the same district, so it's not like what the school doesn't want is for you to pick the house where they see dad once in a while, but they have a better school district. That's not fair. So that's what the school is concerned with. But if you have both parents in the same district, there's nothing wrong with calling it co-residential for school enrollment.
Well, I was going to say, Judge, you mentioned about mediation, and I was wondering if you could just briefly tell our viewers, in a nutshell, what is mediation?
Mediation is an opportunity for two parties, whether it's in family law or other areas. Mediation is in all areas of law now. It's an opportunity for them to have a discussion to see if they can settle the problem. People who settle the problem without court involvement are more likely to follow through on what the agreement is than if they're forced into whatever the judge says, you're going to do this, you're going to do that. They might be resistant. But if they have some participation in the final outcome, they're more likely to follow it. So we have a discussion with the two parties. And we hear about their underlying needs, because sometimes I want the child every Wednesday night, and you don't know why. And then in this discussion, you find out that Wednesday night is their church school night, and it's very important to that parent. So you find underlying needs, and you start to teach them in mediation about how to trade things. I really, really need Wednesday night, and Dad says, I really want Saturdays because of soccer. So you find ways to match up their needs and their wants that works.
Okay. In your mediation background, do you run into certain circumstances where one of the parties will want a significant involvement, maybe a residential situation where the child lives with him or her, but realistically, it's not possible
Yes.
based on work schedule
Absolutely.
and travel for business? How do you...
We call that a reality check.
Okay.
And what we do is, okay, Joe, you're really interested in having 1 week, the kids with you 1 week, and then with Mom another week, right? Yes, that's really what I want. What would that look like? Well, what do you mean? Well, what time do you go to work? Well, I leave at 6 in the morning. How would the kids get to school? Oh, well, I'd have my mother come stay with me.
That's right.
What would that look
Bring
like?
in the grandparents.
Yeah, always. What would that really look like? And then you start to find out if it would work or if it wouldn't work and reality check it. And oftentimes they haven't thought about it. And sometimes they come in and they're fighting over who gets the house, because the house they feel gives them an upper hand about what school the children go to, because you don't want to change schools if you don't have to. And so you have to reality check that. Can you afford it? Have you had a discussion with the two attorneys? Have the two attorneys decided who's going to keep the house? And if they say no, well, I'm not supposed to mediate financial, but I can give them homework. Say, okay, I'm going to give you some homework. You're going to go out and look at houses and look at housing, and you're going to talk to your attorney, and you're going to come back next time and tell me what your plan is about where you're going to live. Because if you're living in Naperville and you're living in Lockport, we have a problem.
Yeah.
Right.
So part of my reality check with them is to get them to go out and get some more information.
Have you seen, and I've seen this, I've been on actually either side of this, where generally one parent is the one who takes care of the children and stays at home and shuttles them around every place, doctor's appointments, school, everything else. The other parent, but realistically though, was working.
Right.
True. And then, because now, under the law, different, maybe we'll talk about that, it's no longer a percentage of the payer's net income, but it's income shares where they combined both the gross incomes of both parties, and they look at the Illinois Department of Health Care and Family Services chart to determine what the net is based upon how many children and to do that. So based upon that, what I've seen, and I want to see if both of you have seen that, where all of a sudden now somebody wants to have the
146
child.
overnights.
Right. I want
Which
to
is
have
a
the,
break
yeah,
point
I
for
want it
the
1 week,
change
next
in the
week,
amount.
Right, although that's never happened. So have you seen that, and has that been an issue?
Yeah, and you see it all the time, and sometimes it gets to the ridiculous. I mean, I had two attorneys, I won't name them so they won't mind, that every time they counted the days that they were with their client, it was different. And it's simple math. You count how many days, and that breaking point would never be reached on one side, and it would be reached on the other side, and I just had to make a decision. You know what I mean? So it becomes a stickler point sometimes.
But I think, and I always thought that what the statute said is, you have 146 overnights. Doesn't say what you're supposed to get, says what you have. And so, and this is the crazy part of it. So let's say mom went on a 1-month vacation this year. So, so I have the kids, this, so you have that kind of a scenario. Or again, dad's never had them this time. And, I want to make sure I get to that 146 or better, just because, well, you know what, Judge, yeah, I didn't have them before, and you know what, I realized that during this divorce process, they need both parents more than they've ever needed them before, and I want to step in, I'm going to, inconvenience myself so that I could be there for my kids. And even though I didn't have the time the last time, boy, I tell you, I sure want to try to make that up.
There is a new law that can be used against that person who's faking it and not going to take as many overnights as he says. And just to make it clear to everybody, the new statute about child support has a breaking point where if you have the child more than 146 overnights, then it changes the mathematical formula and you actually pay less in child support. So there is this fight to get to the 146. But there's a statute that says if I give you a reduced child support and you don't take the children, I can find you in contempt.
For
And
not
punish you.
exercising
Yes.
your which we
And
didn't
that
have
will
before.
we did not have
Yeah.
that before.
Right.
Before we said parenting time was a right but not a duty. But now if you said I'm going to take those, it's now a duty that you can be punished if you don't take it. You'll be found in contempt of court.
I've had a lot of female clients that would always before tell me, well, he's supposed to take them and he hasn't taken them, and it's not much we can do.
Not much
but
we
again,
could have
under the new
done.
statute, you're going to take your kids doggone it whether you like it or not.
Yes.
Yeah, and what I've done in the past with that is I tell with whoever the parent is that's not doing what they're supposed to do, I'll say it in front of them. I can't force them to be a good parent, and they get embarrassed. But now they're gonna be dinged.
Yeah.
Yeah.
And rightfully so, because the person left behind, the person who thinks dad's coming or mom's coming for that weekend and has to work or has other plans, has to scramble.
Sure.
Or give up things, and that's not right either.
Yeah, and that's unfair. I think it's unfair. If you worked out a parenting allocation agreement that says this other weekend he or she is going to have the child, you make plans because you're not going to have the child that weekend. So you may decide to go away for the weekend, and all of a sudden they don't show up. Then what do you do?
Yeah, and then you're out of, essentially you're scrambling and trying to do something. So initially you said mediation's the first stop, and okay, home run, full agreement.
Yep.
Base hit, partial agreement, strikeout, no agreement whatsoever. And so we can't agree on that. So what's the next step? Is there somebody that gets a point? What happens?
Well, a lot of times, there's accusations going back and forth, and of course,
Drug, sexual abuse,
yeah,
violence.
girlfriend is calling, forcing the child to call her mommy, stuff.
Yeah,
It could
well,
be,
that's-
it could be anything.
Yeah.
And so each side is going to be slinging stuff at each other, and I need a disinterested third person to go be my witness, and that's what a GA, a guardian ad litem. It's a person that I appoint to be my disinterested person that's going to go out there and investigate and talk to the children, look at the house, and investigate it all and come back and report to me.
So is the guard ad litem, and Angela, you're a guard ad litem,
I am.
correct? Guard ad litem do you represent the children, or do you merely report to the court on what you believe, based on your investigation, is in the best interest of those kids?
A guardian ad litem represents this persona that wraps around a child called their best interest. I could be a child's attorney, and I represent just the child, as if he were my client.
So it would be like the attorney representing the husband or
Yeah.
the attorney representing
If
the wife?
my
And you'd have to listen.
I would have, if I want to live with Uncle Joe because he grows pot in the backyard, we're fighting for Uncle Joe. We hardly ever have attorneys for the children because we don't quite want to represent what they want oftentimes. But if I'm the guardian ad litem, I represent this thing called the child's best interest. And even though I'm a grandmother, and I would make up my own list, I'm required as an attorney to follow the list that the legislature gave us. It's called the best interest factors. And they have changed. What changed from the old law to the new law is they really just put into words the catch-all category of whatever
Common
else.
sense
Common
stuff,
sense.
right.
Common sense. Who has been the primary caregiver, the 2 years preceding the
Sure.
filing? What are the child's wishes? What are the parents' wishes? Has there been any alienation?
Domestic violence.
Domestic violence is in there. There's each party's ability to keep the other parent involved. There's a whole list of things that we look at to see what's the best interest to who should have primary parenting.
So is there something that's in the middle of a attorney for the child and a guardian ad litem?
There's a third designation. I'm not sure it's in the middle. It's more linear. That's an attorney. We have an attorney for the child, a guardian ad litem, and a child's representative. Child's representative is kind of like a guardian ad litem, except there's confidentiality. With the guardian ad litem,
With the
there's
children?
Yeah. If I'm the guardian ad litem, I get subpoenaed. I have to testify. I have to disclose my notes. There's no confidentiality, which is okay with little kids. But if I have a 14 or 15-year-old, I might want confidentiality. I might want them to be able to tell me things and not have to tell other people, not have to tell their parent. Let's say that the 14-year-old girl had an abortion.
And as a guardian ad litem, can you participate actively in the litigation?
I believe you can. I think I've got case law that supports it. Most of our judges let us.
And
We have to file an appearance.
appearance and an answer.
Yep.
And with respect to a child rep, then obviously, if it's attorney for the child, okay, that's your attorney. But so for a child rep, then
They can
do they have
give
confidentiality?
They do, and but they give recommendations in pretrials. That's where the recommendation comes out. Guardian ad litem usually files a report with the court, and we are the courts. They used to call us the eyes and the ears of the court.
The right arm.
Yeah, but we've evolved, I think, since then because we have 3 duties. We investigate, we report to the court, which was the eyes and ears, but the third duty that's in the statute is we make a recommendation. And that's a really high duty. We have to be very careful. We're recommending people's lives. We're an invitee into their homes. I mean, I do house visits. I'm in the kids' bedrooms talking to them. I look in the refrigerator and the cabinets. I mean, really invasive sometimes. It's uncomfortable, but it's what has to be done.
How about the child rep? Does the child rep do those things as well?
I've been a child's rep. I do all of those things too.
And so the difference between the two, you said
It's
you have
confidentiality. You don't
you
file a
don't do
report.
and you can participate actively in litigation.
can, and
Can I
you
call
give-
you as a witness as a child rep?
No,
But I
I
can
don't
as a
believe so,
guardian
but
ad litem. Right.
don't hold me to that.
Yeah, I did.
Because
judges
it's
will do.
confidential, so I don't know.
Sure.
Let's go back to the home run. You said they go to mediation, they work out an agreement, whether it's pre-decree or whether they file the case or not. Eventually, it's going to be reduced to writing, and it's going to appear before the court and before the judge for what we call prove-up, so that we can actually finalize it. Judge, can you talk about the different safeguards that you have to make sure that the agreement is not unconscionable, and that the division of property seems reasonable, because you might not have seen these litigants before. They might be coming in the very first time before you with this long agreement saying we've worked it out, and they want to get their divorce in 5 minutes in front of you. So what do you do in your role to make sure that you're following the statute and that it's fair and equitable?
You know, and that can be it could be difficult because first of all, they're two adults, and they have a right to decide what they're going to do. It's pretty much contract, right? And then you have a lot of them have attorneys. So I make sure that, for example, that the one side realizes that there's things in the law that guarantee them. There's the guarantees in the laws for them, for their protection. So,
Right.
for example, maintenance, which used to be called alimony, there's a formula now that you use for maintenance, and sometimes you'll have somebody come in and waive it and say, I don't want maintenance.
Even though somebody's making 100 and somebody's making 20.
Yeah, and usually, not always, because it's changing now, usually it's the woman that's waiving it.
And she's the one that makes the less.
Yeah, yes. So if I have somebody that's making $20,000 a year and the other person makes $150,000 and there's no maintenance, I'm not going to accept that agreement.
Okay. So you'll inquire as to if it's a knowing, voluntary,
Right.
sound decision?
Yes,
Okay.
yes, yeah.
And what
you
about
know,
property? What about real estate that they want to divide and sell and split it up a weird way that almost sounds unfair?
I started 50-50,
Okay.
okay? I mean, all marital property is really 50-50. They can,
But Judge, the house is only in my name, it's not in hers.
well, if it was
Well,
bought,
Judge, I made all the payments on the house
yeah,
We've
yeah.
heard that.
All she did was stay home and take care of the kids.
That's right, yeah, yeah.
for 25 years.
Right, yes.
Right.
Yeah, so, yeah, normally if they can't agree on the house, I sell it, and it's going to be split.
Yeah.
And now what they want to do with that money, they can decide how they're going to, but if they can't decide, I'm going to split it 50-50. But what ends up happening is you fight over a house, and you're starting at 50-50, and you're arguing, and then you go to trial, and you get your 50-50, but it's going to go to the attorneys.
It's true.
You know, so work it out. I mean, it's not, you know, I'm not going to use the exact words from a friend of mine's, but it's not rocket science. You know, it's a lot of it is using your head. I mean, I've had people literally, and I'm not talking about Angela now, that are in debt to $100,000 on a simple case, and they could have worked it out.
But that's because the parties complicated the case, or because there was an unreasonable party or attorney on the other side, or, and I'm speaking from experience, there was a self-representing litigant on the other side that forced the time involved.
Or possibly a motivation on one of the parties' parts where they feel that the marriage was destroyed, someone had did something, and they don't really care if they lose
just want
everything
revenge.
because they want to get a pound of flesh. Is that what
Right,
you said?
they want their pound of flesh, but I think that most people, not all of them, there's people out there that really don't care. But I think that most people, when they do that, 10 years from now, they're going to say, boy, I wish I had that 50,000 right here, right now.
Absolutely. Maybe even sooner than that.
Yeah.
Yeah.
And remember, the ones at trial, that's only 5%. Everybody else settled already. So you've got the
Right.
people at trial that have difficulties. They have other
But
issues too.
did they settle early when it was
Or getting
smart?
up to that,
Or
right?
did they wait 2 years down the
Sometimes.
road when
Yeah,
it was already
yeah.
Or
Or
wasted?
the eve of trial, yeah.
Yeah.
And
eve
they've
of
seen the
trial,
judge
sure.
30 times already where
Yeah,
they didn't
that could be.
necessarily need to.
And there's things that you can do. Like, for example, if there's two attorneys, we could do what they call a pretrial.
Yes, could you please talk about that, Judge?
Yeah, they
How
send,
that works in your
they'll,
courtroom?
they'll send me their positions, you know, and normally, you know, 3 days, it's 3 days, right? Tuesdays, 3 days before the pretrial. And I read everything that comes into my chambers. You send me something, I'm going to read it, because I figure if you put in the time to put it together, I'm going to read it and look at it. So they send me the pretrial memos, and then each side puts their position, and I know the law, so I'm going to decide, you know, okay, they're asking too much here, and then we sit down on the third day, just me and the attorneys, and we hash it out. I
In
say,
your
well,
chambers, right?
in
Not
my
in the presence
chamber.
of the parties or anybody
Right.
else in the
No
courtroom.
recordings.
So it's very private,
Right.
and you're able to voice, Judge, tell me if I'm wrong, exactly how you're feeling based on what you see.
Yeah, I'll
And
tell
if someone's
them,
being unreasonable, you might turn to that attorney and say,
yeah, they're being unreasonable, they're not going to get this, and more than likely, this is what I'm going to do if we go to trial.
and that's important because you'll be the judge hearing it.
Right.
In some of the counties, the judge that they're pre-trying in front of is not the
Doesn't-
judge that
yeah.
they're going to get sent to the trial on.
So you
Yeah.
get a second bite at the apple, essentially,
Yeah, and
It
bad.
encourages you to go the next
Yeah.
step if you didn't like that step.
like
Correct.
arbitration.
right. So I sit down and I tell them what I'm going to do, and I try to be real consistent on my ruling so that they pretty much know what I'm going to do. And a lot of times the attorneys themselves, most people think that attorneys are unreasonable. I mean, I've had attorneys that sometimes I wonder if they were divorcing each other in front of me. But
I've got to remember that.
yeah, but most attorneys are reasonable, but they just can't get it to their client that they're asking for something that's more than they're going to get. And they really don't want to take all the client's money, but the clients are, they want that pound of flesh, so they want to hear it from me, so they can convey it to their clients. This is what the judge said. We can go to trial, and you're going to end up with the same thing, but you're going to have a lot less money.
But so that's a great way then to save money in terms of a pretrial, because at a pretrial, you're going to hear things that might not come into evidence.
Right.
And it gives us a chance to do something quickly, as opposed to, again, a lengthy trial. So in order for me to lay a foundation, in order to introduce certain evidence, it might take a couple hours, might take a couple days, which is going to extend that.
Yeah, and Angela will tell you, I'll have two litigants in front of me, and I'll tell them in front of their attorneys, work this thing out, work it out, because you guys if you work it out, you're gonna go home with a little bit of money. If you don't work it out, these two are gonna have all your money.
A little debt there, right?
And one
Yeah.
thing I like about you, Judge, is that even in the middle of a hearing, which is not a trial, if two attorneys have some issue that we can't resolve, we'll ask you for a quick pretrial, and he'll take us out to the conference room and get us past that little bump so that we can come up with an agreement.
Sure. Oh, actually, I know there was something, I want to digress just a little bit, and I apologize. When we were talking about the garden ad litem and the child's rep and all the other stuff, and the recommendation is made, do you have to follow that recommendation?
No, I don't. But when I appoint somebody to be the guardian ad litem or the child rep, it's somebody that I really trust.
So they hold great weight in terms of, because they did the investigation essentially
Yes.
that you can't do.
Yes. And GAL, and these kind of positions, you can make a good living off of those. And so I look for attorneys that are not really looking, that are sincere about trying to get them to work it out, which Angela's one of them, not just because she's sitting here. But I appoint people that are not going to gouge the client. And that's what I try to do.
On that topic, if we can talk about the apportionment of fees, either for the guardian ad litem or for the underlying case in terms of attorney's fees, how does that go, Judge?
Well, you want to have a level playing field. So you sometimes have one person, and again, it's changing. So most people think of the man, but it's changing. Women are making a lot of money now. They'll argue that it's not level, and it probably isn't. But sometimes it's not just a man has a lot of money because they have a very good job, and the other person either is not as educated and doesn't have as good a job, but you want to be able to level that playing field. So you look at what the attorneys charge, and if it's disproportionate, I may grant some money to the other side that doesn't have as much money, because you got to give them both a shot at the court. So that'll happen.
Well,
Judge David Garcia, thank you very much for being here. Angela Henderson, thank you as well.
Thanks for having us.
On behalf of my co-host Jesse Barrientes, I'm David Siegel. We'll see you next time on Legal Action. Take care.
That one.